I'm going to start out by introducing the moderator, and he'll introduce the panelists today. We're real happy at CASE that our law students and graduates have gone on in the last couple of years to do extremely important things. And one of the first to pave that road was today's moderator over here, Chris Rossi. Chris Rossi, who was an editor of our Journal of International Law, went on to be a clerk at the Supreme Court of South Africa, and then clerked for the Yugoslavia Tribunal. He worked for a couple of years at a major law firm in Cleveland, and then got a job as the senior advisor to the judges of the Rwanda Tribunal in Arusha, where he was for several years, and now he's an international arbitration counsel with clients all over the world and having a great time. And we're just glad to have our alumni return, and thank you, Chris.
Thanks, Michael. Good morning, and welcome to the first panel discussion of this conference on substantive elements of the crime of aggression in contemporary case studies. With us today, we have Professor Bill Shabbos, Professor and Director of the Irish Centre for Human Rights, National University of Ireland, Galway. He's a professor at the University of Warwick School of Law, Queen's University, Belfast, and professeur associé at the Université du Québec à Montréal, and author of the book, An Introduction to the International Criminal Court. Professor Mark Drumbl, class of 1975 alumni professor of law and director of the Transnational Law Institute at Washington and Lee University College of Law, and author of Atrocity, Punishment, and International Law, which won last year's book prize from the International Association of Criminal Law. And Oscar Solera, a human rights officer in the Office of the UN High Commissioner for Human Rights. He also served as human rights officer for the UN Human Rights Council Commission of Inquiry on Lebanon, and he is the author of the book, Defining the Crime of Aggression. The topic of this conference, crimes against peace and the crime of aggression, and the issues we will address in this panel are especially important given recent conflicts. Last month, ICC prosecutor Luis Moreno Ocampo confirmed that the situation in Georgia, which is a state party to the Rome Statute, is under analysis by his office. Since the outbreak of violence in South Ossetia and Abkhazia, it has been revealed that the ICC is monitoring the situation and is formally consulting the governments of Georgia and the Russian Federation. It remains unclear, however, whether any war crimes committed in Georgia would reach a degree of gravity that would warrant the opening of a formal investigation. However, commentators have questioned whether the actions by the Russian Federation constitute an act of aggression, yet to fall within the subject matter jurisdiction of the ICC. The situation in Georgia is just one contemporary example of where the use of armed force has been publicly labeled aggression. Other conflicts worth examining include NATO's humanitarian intervention in Yugoslavia, regime change in Iraq, and the invasion of Lebanon. As we confront these and other situations, it is important to identify the elements of the crime of aggression, and we will consider the concept of crime of state and the policy elements, including its characterization as a leadership crime and supreme crime, whether contemporary security, stability, and human rights interests warrant an expansion in what constitutes an act of aggression, and how the definition of aggression can avoid the problems highlighted in the London Charter negotiations and the International Law Commission discussions, and how the definition has been taking shape in the Special Working Group on the crime of aggression. We have been introduced to the historical evolution of the crime of aggression. Despite the hesitation of the UN War Crimes Commission to include the crime of aggression, it evolved between 1945 and 1947. However, as has been noted by one expert, at that stage, the crime fell into oblivion. Not surprisingly, since 1947, there have been no international trials for alleged crimes of aggression, although it is clear that states have engaged in acts of aggression in breach of Article 2.4 of the UN Charter. While the statutes of the modern tribunals are inspired by the Nuremberg precedent and its principles, their jurisdiction is limited to crimes of jus in bello, war crimes, crimes against humanity, and the crime of genocide. Crimes against peace and the laws governing the resort to force and aggression, known as jus ad bellum, are not mentioned in the statutes of the ICTY and ICTR. Yet, we are at the point where the debate about aggression and the ICC statute is at the forefront of discussions of state parties and human rights NGOs. Although there have been a couple of instances of crimes against peace prosecutions that have received little attention, there is a dearth of actual examples. Only recently have alleged cases of aggression been brought before some national courts, or have national prosecutors been requested to open investigations into alleged instances of aggression. Similarly, although the statute of the Iraqi High Tribunal grants jurisdiction over the crime of aggression against other Arab countries, so far nobody has been tried for this crime. That brings us to a main point of contention during negotiations for the Rome Statute and the Special Working Group, the role to be reserved for the UN Security Council. Should its determinations be binding upon the court? And could it thus stop the court from prosecuting alleged cases of aggression? Or should the court instead be free to make its own findings? And will the recent events concerning the Bashir arrest warrant application heighten concern about aggression and the role of the Security Council in defining and determining which cases should be prosecuted? As a final point, we should also inquire about the practical effects of the crime of aggression in court statutes. Does it accurately characterize criminal conduct? Is there a current gap in international criminal law, considering it is very unlikely that someone will be charged with aggression and not subsequent jus in bello crimes? And what are the penological purposes of sentencing an aggressor? I'll now pass the floor to Professor Shabas, and then we'll reserve 15 minutes for questions at the end of the panel presentations.
Okay. Thank you very much, Chris. And let me start by thanking Michael Scharf and Case Western Reserve School of Law for inviting me and for organizing this conference, as Michael mentioned this morning, one in a series of fascinating and influential gatherings that have been held in this room over the years. I think it was Henry King who, at the outset of our discussions this morning, recalled the reference to Nuremberg as the supreme international crime. This is how the judges in the final judgment of the International Military Tribunal described crimes against peace. And they expressed a vision of crimes against peace being the supreme international crime within which was subsumed the evil of all the rest. That's how it was formulated. But if we back up a year and a half or so, 2 years before the judgment, to the debates in the United Nations War Crimes Commission, we find that actually there was considerable uncertainty about whether the crime should even be recognized under international law. Ultimately, of course, Justice Jackson and the others who drafted the Charter of the International Military Tribunal agreed to include crimes against peace. But I have always found it to be an intriguing situation that crimes against peace are the supreme international crime in 1946, but in 1944 they're not even sure whether they're a crime at all. And of course, the judges, although they said that they were the supreme international crime, didn't necessarily behave as if they believed it. And so when it came to sentencing people, the one individual who was convicted of crimes against peace alone, Rudolf Hess, got a life sentence, and the one who was sentenced to crimes against humanity alone, and not to crimes against peace, Julius Streicher, got the death penalty. And of course there were famous debates as well at the Tokyo Tribunal and some dissents about this issue of crimes against peace. So there's always been an ambivalence about it. There's been a cloud over crimes against peace as to what exactly its position was in the general scheme of international criminal law. Now, one could say that with the Rome Statute of the International Criminal Court, this is resolved, because Article 5 says that aggression, the crime of aggression, is a crime within the jurisdiction of the court. And the preamble in Article 1 go on to say that the court has jurisdiction over the most serious crimes of concern to the international community as a whole. So based on this, one could say that it's already accepted that the crime of aggression is among the most serious crimes of concern to the international community as a whole, and that it belongs within the Rome Statute. But I think on closer scrutiny, one would have to say that the debate at Rome was fudged a bit on that issue. We know that the Bureau, in the middle of the Rome Conference, or about the end of the third week of the Rome Conference, attempted to clarify issues and said in a paper, a discussion paper that was produced, that unless they could make more progress on defining aggression, they would have to drop it. And this provoked a great outcry. in the Committee of the Whole, statements were made by many delegations saying that this was unacceptable and that the crime of aggression had to be included within the statute. And at the last minute, on the final day of the conference, the compromise was to put it in the list in Article 5. But it kind of short-circuited a debate about whether it really did belong, and I think that there were some states who feel that it didn't belong, who retreated into their shell at that point and figured that since it was in an emasculated provision, Article 5, where it couldn't do anything, because Article 5, Paragraph 2 says the court can't exercise jurisdiction over the crime of aggression until it's been defined and until the relationship with the Charter of the United Nations has been resolved. States that I think were ambivalent, neutral, indifferent, or opposed to aggression being in the statute simply decided to lower themselves below the radar and not to fight anymore on this question. But they're out there. And it's an obstacle that at some point is going to come forward, I think, before this matter is finally resolved, if it is ever resolved. Another area where we can see this ambivalence about the position of aggression, the crime of aggression, is in the position taken by some of the major human rights non-governmental organizations. Both Human Rights Watch and Amnesty International, I think also the International Federation of Human Rights, have essentially said, we don't have a position on this, we're not engaged with the issue of aggression. Human Rights Watch says, we're only involved with the jus in bello, that is the law applicable to the conduct of hostilities, and we're not interested in the jus ad bellum, which is the law of the legality of the conflict. I think Human Rights Watch has simply confused international humanitarian law with international human rights law, which is supposed to be its source of inspiration and its mandate. Amnesty International has done much the same. Its position is expressed a little differently. Amnesty says it gets its mandate from the Universal Declaration of Human Rights, and therefore there's nothing about aggression in the Universal Declaration of Human Rights. I think that's so fundamentally wrong as a question of the law of human rights. First of all, the Universal Declaration of Human Rights has a reference to peace in the first sentence of the preamble. It has a reference to freedom from fear drawn from Roosevelt's speech in the second sentence of the preamble. It talks about the importance of friendly relations between states in the fourth sentence of the preamble. The language of freedom from fear is continued into the preambles of the two covenants on human rights. There's a provision in the Covenant on Civil and Political Rights that makes propaganda for war prohibited. I don't challenge the idea that the idea of the right to peace and its role in international human rights law is underdeveloped, which I think is a fact and an unfortunate one. But to suggest that it's not there, as the human rights NGOs do, is, I think, just plain wrong. And to transpose the jus ad bellum, jus in bello issue from international humanitarian law, which is what Human Rights Watch does, is to ignore the fact that international humanitarian law creates the rule of jus ad bello, or the distinction between jus in bello and jus ad bellum, related to a time when we were dealing with international armed conflicts. And so it was an important rule to create a body of law that would govern how soldiers of rival countries behaved on the battlefield. It doesn't make any sense in human rights law, where we're concerned essentially about the relationship between the state and the individual. But the fact that they have failed to bring their energy, which has been so important in other aspects of building the International Criminal Court, to this campaign has hurt it, I think, quite terribly. And I do believe that if we're going to make progress before the review conference and finally resolve some of the outstanding difficulties, that this has to be challenged more directly, and they have to be called to account, the human rights NGOs, and we have to bring the states that are opposed or neutral or ambivalent on the question, we've got to draw them out and settle this matter. Or we won't. I think we'll have great difficulty at the review conference. Let me turn to a second issue relating to the incorporation of the crime of aggression in a proper sense, the activation, let's call it, of the crime of aggression within the statute, the Rome Statute of the International Criminal Court. In many ways, it stands as an anomalous kind of a crime. It doesn't fit the same mold as the other three crimes within the jurisdiction: genocide, crimes against humanity, and war crimes. For example, it doesn't really fit with the complementarity paradigm of the court. The idea of complementarity is that states will address these crimes within their own justice systems. And if we can set aside the technicalities of the definitions of genocide, crimes against humanity, and war crimes, most states within their existing criminal codes can already prosecute most of the terrible atrocities, often under the rubrics of murder, rape, and so on. But they can't do it with aggression. There are very few examples of states that have actually incorporated aggression as a crime within their domestic law, and even fewer who've actually contemplated prosecutions. So it doesn't quite fit. It's different in nature. There's been little discussion about how the crime of aggression would work with respect to victims. Those of you who follow the court know that the victim business has become quite an industry, actually, at the International Criminal Court. There are more victim lawyers involved in the International Criminal Court, I think, than defense lawyers and prosecutors combined, and then you could multiply by 5, and you still wouldn't come near all of the activity around the victims. And I'm just intrigued to consider how many victims we'll have for the crime of aggression, and how many victim lawyers are going to be queuing up in The Hague to represent the victims of the crime of aggression. It just boggles the mind. The other element that I think is worth a few comments about the anomaly or the distinction between aggression and the other crimes is the growing consensus that aggression should be treated as a leadership crime, a crime that can only be committed by those in a position to control policy or to change policy or to develop policy of a state. And there it's completely at odds with what we say about the other crimes. Professor Bassiouni a few minutes ago referred somewhat facetiously to the idea of Corporal Ferencz being crossing the border and committing aggression. And of course we know that if Corporal Ferencz crosses the border because General King told him to do so, that because it's a leadership crime, he's off the hook. If General King tells Corporal Ferencz to commit a crime against humanity or a war crime, he's not off the hook, because we don't allow the defense of superior orders. The paradox of all of this is that by making the crime of aggression a leadership crime, is in effect we elevate the defense of superior orders to it's an ironclad defense, actually, and all you have to do is say, someone ordered me to do it, to give you a full defense. And it's a bizarre result in a way. It's a pragmatic one, fundamentally, isn't it? Because the idea of telling individual soldiers, as we tell them about war crimes and crimes against humanity, that if it's a manifestly unlawful order to invade another country or to commit an act of aggression, that they're not supposed to do it, is such an unthinkable idea for militaries around the world, and that's the problem. The other thing, though, that this idea focuses our attention on is that aggression is a crime of state. We prosecute individuals for it, of course. We can't prosecute states at the International Criminal Court. But it is nevertheless fundamentally a crime of state. And that means that it's only the leaders who can control the state policy who can commit the crime. And I think this is a very interesting approach, and it's something that it's very helpful that we bring our attention to bear on. In the book that Michael Scharf edited with Leila Sadat, the Festschrift for Cherif Bassiouni, there's an article about something that Cherif Bassiouni has made one of his, I think, the themes of his approach to international criminal law, the insistence on the state policy element in the definitions of crimes, and particularly of crimes against humanity. It's a minority position, I think. It's one that's been rejected by the International Criminal Tribunal for the former Yugoslavia, but it's one with which I agree. It's why I wrote the article that praises Cherif's position on this matter in the Festschrift. And I think that we are seeing some interesting transformation in the case law, even of the Yugoslavia Tribunal, where in the early days there was a very strong tendency to dismiss entirely the idea that these are crimes of state and that they involve state policy. I think it was driven by pragmatism. It was because the Yugoslavia Tribunal was chasing low-level perpetrators along the lines of Tadic and Jelisic and Kunarac, for whom they couldn't demonstrate a state policy. They couldn't make the case, and so the judges twisted the law to fit the patients, so to speak, or to fit the accused. And in recent years, in the last few years, as they go up through the chain and prosecute higher level offenders, and we see this now in the judgments, in the appeals judgment in Borjanin, in the famous individual opinion of Judge Bonomi and Milutinovic, that increasingly they're coming back to the idea that state policy is important. And I think ultimately Cherif Bassiouni's position is going to be vindicated on this. And also I think that the idea in bringing these together, the idea that aggression is a leadership crime, may start to have a ricochet effect on other categories of crime as well, including crimes against humanity. The final point that I want to turn to for a few minutes is what I think is the outstanding and unresolved issue about activating the crime of aggression within the jurisdiction of the International Criminal Court. And that's not about the definition, because the work of the working group chaired by Ambassador Veneweser has made fabulous progress. The outstanding technical issues largely resolved, solutions have been found. This is all eminently solvable. Compromises will be made. Delegates will agree that they don't have strong positions on one option or the other, and we'll get clarity. The same with all of the other technical issues. But there's a big issue on which I don't think we've made a great deal of progress, and that's the issue of the Security Council and Article 39 of the Charter of the United Nations. Now we have in the proceedings of the working group a number of solutions. There's lots of debate in there. But the problem, the obstacle for that is not getting the members of the working group to agree to a solution, and it's not getting a majority of the Assembly of States parties to agree to a solution, because there are 5 countries who have a very important say in this issue, and they haven't even blinked, from what I can determine. They haven't moved one iota. They haven't suggested that they're prepared to compromise. It's true that the review conference could take a vote that would be 106 to 2, I suppose. That's possible. The 2 being Britain and France, and the other 3 permanent members not even having a vote. But I think that's politically very unlikely to happen, that they will defy the 5 permanent members of the Security Council. I think that unless they make some movement, that it's going to be very difficult to resolve. And I don't see anything that has happened yet to suggest that they're prepared to make any compromise in that respect. And I just want to raise as a final point what I think the recent developments concerning the threatened arrest warrant of President al-Bashir of Sudan are only going to heighten this problem, because what we now have is a growing political difficulty. First of all, the African Union countries, but now joined to some extent by France and possibly, I think, by the United Kingdom, who are clearly unsettled at the idea that the great political crimes, and when you want to prosecute a head of state, there's nothing more political than that. As you get closer to that this is a daunting and frightening proposition for many states. And so to the extent there's cold feet about letting judges or the prosecutor make determinations about the crime of state of aggression, I fear that these recent developments are only going to sharpen that. It's obvious that something very dramatic has happened since July, because when the other 2 Sudanese were charged, Well, nobody really, people shrugged and said, I wonder if we'll arrest them and we'll move on. But there's something very dramatic about threatening to prosecute a sitting head of state. And I think that's changed something in the chemistry of all of this that's going to make this problem of overcoming the opposition of the 5 permanent members of the Security Council even more difficult than it already is. Thank you.
Thank you. Professor Chavez, Professor Drumbl.
Thanks, Chris, and good morning to all of you. I'd like to echo Bill in underscoring how this annual tradition for us to meet at CASE and talk through these issues is a wonderful focal point for not only our community as international criminal lawyers, but also to keep a dialogue going. I have tentatively entitled my remarks this morning as follows: the push to criminalize aggression. Is there something lost amid the gains? And what I would like to do is advance a bit of an outsider's argument that those who care about the crime of aggression and the special working group might expand the discursive focus of their work. And what I hope to do is suggest a conceptual adjustment to how we construct the substantive elements of the crime of aggression. And I'd like to draw from what I see as contemporary security threats. And I'd also like to go back to 2 cases of crimes against the peace convictions that occurred in 1946 that no one really talks about. And those are the convictions of Takashi Sakai by the Chinese War Crimes Military Tribunal in Nanking, and Artur Greiser of the Supreme National Tribunal of Poland, both of whom were not at the top of the overall leadership chain, and in Sakai's case, were actually convicted merely for participating in an aggressive war. So let me start off by talking a little bit about what I would like to see mapped out regarding the act. In other words, the what do we mean by aggression? And then secondly, I'd like to talk a little bit about punishment and sentencing. My talk is not a pragmatic or political one. It is not an instrumental one. It's a deeply normative one. It's one that pushes how we ought to think of the problem, not necessarily get to a solution. And I would underscore that to some degree, that is how international criminal law started out, as we learned this morning from both Ben and Cherif. Let me start off with the following predicate, and that is this. It is groundbreaking to think of aggression as a crime. However, the understanding of aggression as a crime has largely hewed to a very traditional, narrow, and now customary paradigm of interstate armed conflict in the way that Cherif had set out this morning. And I think there's a lot to celebrate in thinking about how that particular conflict, when rendered illegally, ought to be criminalized. And I think that a lot of our conversation is wise to continue to frame the act in a very limited fashion. But perhaps naively, I'd like to raise the following point, and that is this. Should we challenge the conventional wisdom of this narrow framing of the dialogue and of the discussion? And let me ask this, what do we hope to achieve by criminalizing aggression? I would argue we hope to protect 4 interests. First interest is stability, the second is security, the third is human rights, and I think Larry May has set an ambitious agenda in this regard. And fourthly, I would say, is the sovereignty interest. So if we aim to protect these 4 interests, stability, security, human rights, and sovereignty, and we take those as legitimate interests, the question that I have is this: is criminalizing only interstate armed attacks that flagrantly violate the jus ad bellum is criminalizing only that narrow band of activity, something that captures the key stability, security, human rights, and sovereignty challenges that we face today and that the international community has to deal with. In my opinion, the answer to that is no. And I think that we need to conceptualize a variety of other phenomena as threatening these four interests in many ways that are as worrisome as traditional interstate armed conflict. And I'm thinking of non-state actor violence, attacks, for example, by terrorist groups such as Al-Qaeda or by narco-terrorist syndicates, internal armed conflict. Another one are attacks by states against their own populations. Pushing the envelope even further, what about widespread environmental harms? What about macro issues such as climate change, which, let's just be honest, could very well have the effect of disappearing territory, or in some cases, even small island states, triggering massive refugee movements? What about cyber attacks? What about public health pandemics? To varying degrees, each of these phenomena pose serious threats to all four of the interests that I believe the crime of aggression ought to protect. Now, it's obvious, some of these threats don't occur through intentional action. Particularly, these much more difficult to conceptualize threats like those that are environmental and health in nature. Others do arise from intentionality, in particular non-state actor violence or violence by states within internal contexts. But the concern that I have is that the narrow framing of our conversation as to what is aggression omits a serious engagement with these particular threats within the framework of international criminal law, notwithstanding the fact that these particular threats could very well occasion similar effects to those associated with interstate armed conflict. Now, obviously, there's a pragmatic reason to limit the conversation, and that pragmatic reason is that there is no law in practice, even when it comes to criminalizing interstate armed conflict in the most classic sense of aggressive war. And I recognize that there is a major advantage in limiting the conversation so as to promote consensus within the work of the Special Working Group and within those who care deeply about the crime and want to see it included in the Rome Statute. But as I said before, this talk is not about pragmatics. This talk, and what I hope to contribute to the conversation, is about a much bigger picture than that, which is, in my opinion, moving an understanding of the crime of aggression and the interests it protects into a contemporary category where security threats are much more diverse in nature, and achieving the goals that we want to achieve may by necessity entail expanding a conversation and certainly not stopping the conversation once we achieve codification of aggression within the International Criminal Court statute. And I think that is also a very important point. In a lot of my work, I have warned that law can in many ways present premature closure to very complicated issues. And just because we achieve a definition of aggression in the Rome Statute by amendment, and a lot of states sign on to that and adopt that, doesn't actually mean that we have done much to either A, necessarily punish individuals who end up committing that crime, but more importantly, that we've actually addressed the key security, human rights, stability, and sovereignty interests that we ought to be concerned about. And I think there's a lot of value in conversation, discourse. The entire expressive value of law is something that I have thought about to some degree, and I feel is one of the most important legacies of international criminal law, particularly in the case of the Rome Statute, where we have to recognize that one of the major obligations of those involved in amending or thinking about it is to see that the ICC has jurisdiction, but the Rome Statute has a tremendous law reform value. It has a huge spillover effect on national jurisdictions and on creating broader conversations about what we hope to achieve. And I think in this sense, there is some value in expanding the conversation about what exactly is an act of aggression, notwithstanding the considerable complexities that this might throw into the utilitarian purposes of the conversation. And I guess one answer to that one could raise, and I'm actually very pleased that Cherif brought this up this morning, is just because the special working group or those who care about the Rome Statute might expand the conversation doesn't mean that for a lot of the security threats that I identify that punitive criminal law necessarily ought to be an appropriate responsive mechanism. And this could very well push a conversation into an area of state responsibility, organizational responsibility, and other aspects by which we need to think about how contemporary security threats involve so much more than interstate war. The second set of questions that I'd like to unpack involve punishment and sentencing, a topic that is very important, I think, and yet at the same time is somewhat understudied. I've written elsewhere that international criminal law has not yet developed a coherent penology with regards to how offenders are to be sentenced and why. There are a number of rationales that are raised: retribution, deterrence, something I call expressivism. On a subaltern basis, we have incapacitation, even reintegration to some degree, rehabilitation, reconciliation. I think that the work of the Special Working Group and others who think about the crime of aggression would most definitely be wise to think about how and why ought an aggressor, I guess let's just use that word for someone who's convicted of aggression, how should an aggressor be punished and why? What are the penological objectives that we hope to achieve in this regard? This morning, Cherif told us that, in his opinion, deterrence might not necessarily be a viable justification. I would agree with him in this particular regard. And I also think that we need to be honest that even if deterrence were a particularly viable rationale that could be achieved by ICC prosecution, if we accept that, then I think we also need to have a conversation about what kinds of other conduct that might squeeze out or deter, namely the thorny thicket of how do we deal with humanitarian armed intervention or proactive intervention on the ground to prevent genocide, for example, something many of us would like to see happen, and I would argue that many victims might very well like to see happen. Similarly, should the penological rationales of aggression parallel those of genocide or crimes against humanity and war crimes? And how do we explore that particular intersection? Particularly in light of the fact that it seems to me that there would be few defendants before the ICC or any punitive institution who would be hauled up on charges of aggression in the absence of any evidence that atrocity crimes also were committed. And how does that necessarily interface, and what challenge does that put forward for penological justifications? Bill talked about the leadership requirement, and in this very valuable contribution to the conversation, I might push the dialogue a little bit further and say that if we truly are to recognize that aggression is a system crime, aggression is a collective crime, I wonder to what degree focusing only on a very narrow leadership requirement reflects the reality that forget about the private, without mid-level officers, without senior officers, without a lot of individuals below the top leadership ranks, there would be no war effort and there would be no war. How do we recognize that within an overall sentencing framework if, to some degree, there is no liability for individuals below those very top levels? And in this regard, I would applaud creative thinking. For example, an article a couple of years ago by Mark O'Seal talking about how the threat of economic sanctions on officers might create a situation whereby there's a disincentive to join an aggressive war movement. And let's be real and honest. You need the leader, but you also need lots of other people in order to wage an aggressive war. And the extent to which international criminal law does not include those many other people in the conversation, regardless of the impracticalities, it's just a reality. Those individuals are necessary to the war effort, and as I've argued elsewhere for other crimes, some form of accountability for those individuals is necessary in order to have justice. At the end of the day, let me summarize by saying the following. I do think we face two choices. Choice one is the operational one, the pragmatic one. Let's agree on a lowest common denominator definition of what is aggression and who can commit it. Let's put it in the statute, let's celebrate that, and let's recognize that international criminal law has codified what I think we all can agree on is a major cause of global instability and human rights abuses. But then there's a second potential strategy, which is inclusive of the first, either by happening later or happening now. And that is, let the conversation be a reflection of the kinds of violence that today promote as much, if not more, threats to security, stability, sovereignty, and human rights issues. And let's include that within the overall conversation. Because if we fail to do that, I think what we will achieve is a very narrow form of criminalization that, although potentially effective, will fall short with regards to effectiveness and legitimacy because we're not targeting what truly are major threats, not only today, but I would say increasingly in the future. And to come full circle, we also have to recognize that many of the threats that I have spoken of also, in turn, could be grist for the mill of further international armed conflict. So at the end of the day, those are my thoughts. They're very tentative. It's an academic conference, and it's an idea. So thank you for your time.
Thank you, Professor Drumbl. Oscar Solera.
Thank you. Let me add my voice into thanking Michael and Case Western for this for inviting me to this conference. It's a great honor for me to be joining all these experts, very knowledgeable people, and also for the very warm welcome that I was given here in Cleveland. Let me begin with the usual disclaimer by saying that I'm participating here in my personal capacity. I will be thus presenting my own views on the problem, which do not necessarily represent those of the Office of the High Commissioner for Human Rights. That being said, it's always hard, of course, to speak at the end of a panel when everyone is craving for a cup of coffee. So I'll try to go straight to the point. I won't take the idealist approach to these questions. I'll try to be a lot more pragmatic about what are the problems for reaching a definition of aggression that could work in a specific context. The problem of aggression, of course, you can approach it from the academic perspective, trying to reach a very sound legal definition of aggression. Or you can try and reach a decision on a definition that could, while being legally sound, can be workable within the specific context of the ICC statute. There are two guiding principles that I will be referring to in my presentation. One is that despite our tendency, our very human tendency to have short memories, we should make an effort to learn the lessons from history. This morning, Ben and Henry spoke about some of these lessons, and I'll try to highlight some of the points that I think should be kept in mind in the negotiations in New York. The second guiding principle is that we are dealing with a resolution, with a definition, that needs to respect two interests, or that needs to represent two different sets of interests. First is that it's a state-driven process. So we will have the interest of states needing to be represented in the adoption of the resolution and in the resolution itself. What is it that states want? So that definition would need to contain and properly reflect those interests. The second is that we have a second user of that resolution, and that is of that definition, and that is the court. And their interests are different from those of states. States will seek to protect their political interests. The court will seek to protect the interest of justice. So how do you conciliate both interests? I have found a very interesting citation, and that I will dare you to find who said it, in what context. It says, and I quote, "Certainly a judge will then say, why did you not, you fellows, define aggression when drawing up the agreement? It is not a clearly defined term of art. We find no body of law that clearly defines it. I am sure that a judge would say that if you charge a man with making aggressive war, it is his privilege to show that the war he made was not aggressive, and it is his privilege to show that in defense or mitigation, provocation, threats, economic strangulation, and that sort of thing." This quotation comes from the London Charter negotiations, and is a statement by Justice Jackson. He realized that in the discussions towards defining aggression, the interests of states were being represented, but not the interests of justice. And his question was very valid. What will judges do with this resolution? Will this resolution serve their main objective, which is achieving justice? I think the answer came a few years later. When we read the judgment of the tribunal, they reached the following charges. Remember, we were talking about crimes against peace, namely planning, preparation, initiation, or waging of a war of aggression or war in violation of international treaties. The court found that acts of aggressive war had been committed, that aggressive war had been committed, that plain aggression had been committed, and that premeditated aggressive steps in furthering the plan to wage aggressive wars had been committed. Now I wonder where the court got all these definitions, because they're not in the London Charter. The Charter talks about crimes against peace, waging a war of aggression, or a war in violation of treaties. So my point is that the judges in Nuremberg were provided with an instrument that was not very helpful. They had to make up for the problems that had not been resolved during the negotiations. And they came up with whatever they could. They had to label different acts or different types of aggressive acts that had been carried out in the war, and try to fit them into something that was given to them that did not apply to those purposes. In the process that was led within the General Assembly, we faced similar situations. States presented their own views, and as Mark said, some of them discussed about other types of aggression, and they said, look, we're not only talking about aggressive use of force, we should include economic aggression. And we should include also aggression in terms of damaging human resource, the environment, or exploiting the resources of another country. Now, these discussions lasted for at least 10 years, 12 years, and they soon realized that they could not agree into what type of definition could be used in order to include both war and other types of aggression. So they said, let's forget about those, economic aggression and the like, and let's concentrate on what we really want to avoid, which is, at the basis, is war. And that's what they did. They dropped economic aggression, and when they reached their final resolution in 1974, what we see is a consensus resolution that, as was said this morning, is a consensus that did not mean a lot. The consensus meant that everyone could live with it, but they understood that the resolution was given in a particular context. And if you see the explanations of states after the adoption of the resolution, you will see that many of them said, well, look, this is a General Assembly resolution. It's for guidance to the Security Council. The Security Council will decide whether they want to use it or not. Probably they will not want to use it. And in any case, the Security Council can add or modify it as it wishes. As it was mentioned this morning, the resolution has never been mentioned by the Security Council, which I think highlights the high regard that the Council has for that resolution. It could have been used in Iraq in 1991. It was not. That doesn't mean that the Council has not referred to acts of aggression or aggressive war. It has. But it has never used the resolution. It has never mentioned it. The General Assembly has on certain cases, but if you review those resolutions and situations, you will see that there is no true consistency to the way it has been used. There's another process that people tend to forget, and that's the ILC discussions from 81 to 96. We have a group of experts, legal experts, well-known people, trying to reach a definition that they think is sound, that can be proposed and is workable for states. They start with a very long definition, and they end up with a two-line definition in 96 that eventually says aggression is aggression. And the persons responsible will be the leaders of the state, and that was it. That was what was proposed in the draft code. The difficulty was that this was supposed to be the basis of the work for the preparatory committee to the Rome Conference. So when you have a definition that says aggression is aggression, it's not very useful. There have been attempts throughout the 16 years in the ILC discussions to use General Assembly Resolution 3314. And despite the very long discussions and impassioned discussions they had, it was impossible to reach a conclusion. And I think the reason was that it was recognized that the resolution itself is not very suited for criminal proceedings. And I have another quotation, this time by Alain Pellet, who was a member of the commission, who was very mad, actually. He was very vocal into the whole process by saying, look, you don't know what you're doing. In fact, we should just drop the idea of defining aggression altogether, especially if you're going to concentrate on Resolution 3314. He said, and I'm quoting, first, the general view was the definition was poorly drafted and did not really show what was meant by aggression. When it had adopted the definition, the General Assembly had known full well that the Security Council would remain free to characterize as aggression as it saw fit and according to its own criteria. Secondly, because the definition of aggression was not in any event meant to provide the basis for characterizing an act as a crime under international law. And thirdly, because as a matter of principle, it's not a good idea to include code excerpts from other texts. So all throughout 16 years of the negotiations in the ILC, there were warnings about the difficulty of transferring this agreed consensus definition into a criminal code as the ICC statute is. I think part of the reasons why the crime of aggression almost was excluded from the Rome statute was that it was very difficult to decide whether 3314 was the right basis for negotiations, and failing to demonstrate that what was Plan B, and there was no Plan B. And fortunately, not unfortunately, there were people who pushed very strongly to keep at least a mention of that crime, to have a second chance into defining it. And we enter into the phase of the working group and the special working group. And what happens is we enter into the same cycle. We stick to Resolution 3314. With all the difficulties, we have exactly the same discussions. If we could take the texts of the discussions from 2000 until 2004 and compare them with the discussions in the 1960s, we will see they are exactly the same. Maybe the actors change, the states are different, but the arguments are exactly the same. I have tried in the book I wrote to provide for a Plan B. And that Plan B is failing to adopt a resolution based on 3314, what could be the other option? And I submit that we would need to use common sense and think as any criminal lawyer would do. Think of the elements. What do we want to include as elements of the crime? What are those elements? And that's all you need. First element is the use of force, the material elements. Now, there has been a lot of discussion about whether simply saying the use of force is aggression is sufficient, or whether we need to qualify it. I think there is a very wide consensus in the sense that not every violation of Article 2.4 entails aggression. There are some forms of uses of force that will not necessarily lead to a crime of aggression. There is a threshold of gravity. That's what has been adopted now. The gravity or manifest violation of the Charter, which, in my view, doesn't mean anything. The gravity of the violation of the Charter or a manifest violation of the Charter, I don't know exactly what that means. I would say that we could take the material element of the use of force as is, so just take it for granted, the use of force, but it's not enough to keep that one. You would need other elements. The other element is the mental element, and that's, as in many criminal law situations, will be the central core elements of the definition, the mens rea, the guilty mind. Cherif Bassiouni spoke today about general intent and specific intent. This is not new in the statute. We have crimes with general intent, and we have one crime with specific intent, and that is genocide. I would suggest that in the case of aggression, we would need that specific intent. That is, we are using force, but for what purpose? What is the ultimate objective that we are aiming at when we use armed force? In my view, that would allow to exclude certain uses of force that are not necessarily meant to be aggressive. If you see how this would work in practice, I have in my book talked about three complex cases. One is the NATO intervention in Kosovo. The second is the American intervention in Afghanistan, and the third one is the American and Allied intervention in Iraq. And I try to show that there is a possibility of finding out what is the specific intent of those leaders when they undertake the armed attack against those states. Some people have argued that it would be impossible to do that. I think that it is possible, that in an era of information technology, especially, it's very easy to have access to deliberations, to statements, to things that heads of states and other top officials have said that would lead to identifying that specific intent. And the last point is, who is the victim of aggression? Are we talking about states, which is usually what the definitions have done? If we see the latest proposal in the special working group, it says the use of force against a state. Now that leaves the question open as to what happens with situations like Kosovo, or other countries that have not necessarily attained statehood. What are the criteria for statehood? An attack against Kosovo, or even an attack against the former Yugoslav republics, at that time, when it was argued that they did not have statehood status, would that have constituted aggression? That's an open question that has not yet been dealt with. To conclude, I just want to take the opportunity to mention two things Henry King and Ben Ferencz said this morning. We have a golden opportunity, and I fully agree. It's a golden opportunity, and we need to grab it. Now, I think I'm more nuanced than Ben Ferencz when he says that there is a definition of aggression and we should just implement it. I think that the golden opportunity should not be a missed opportunity. We need something that works this time, and that definition needs to be a workable definition both for state interests and for the court. Otherwise, we will have a court that will not be able to decide on specific cases of aggression if any case reaches the court. Thank you.
We'll open up to questions. Thank you very much.
I have a question. I wanted to ask Mr. Solari about the question of invasions, such as that in Czechoslovakia and Austria, whether he has any comments on that. I would also add, as a commentary of my own, that I think it's very important to get something in place to at least start the ball rolling. And I think time is running out on us because of the weapons of mass destruction are so destructive. So I'd like to get your comments on that.
Should we get a number of questions or should I answer one by one?
We'll probably answer this one first.
Okay. I would say that, and if we concentrate again on the specific intent, and we take the cases of Austria and Czechoslovakia, there is a full range of documents that demonstrate that there was an aggressive mind on the German side. So the fact that the definition in the London Charter was not good did not help. But if we have a definition of aggression which corresponds to the criminal standards or criminal law standards and essentially concentrates again on the guilty mind, it would have been very easy to demonstrate that aggression had been carried out against Czechoslovakia and Austria. Weapons of mass destruction, very difficult, yes, because can we wait for an attack? The usual standard in the Charter would be that you would need an armed attack to happen before self-defense can be executed, can be argued. Well, in today's world, I wonder whether that would be possible, especially in the context of weapons of mass destruction. But I would say that whether you have weapons of mass destruction or a commando that gets into a country and kills the president, the amount of force is enormously different, but both could be aggression. To me, it's not just the amount of force that is used, it's why the force was used, for what purposes, and what was the result. You can have a nuclear weapon falling on the desert and nothing happens. Would that be aggression?
Second question.
Yes, good evening. I want to make a point that next year will mark the 70th anniversary of the aggression, of the invasion. of Nazi Germany and the Soviet Union of Poland. And I'm of the Polish background. I was born in Poland about 10 years after the war concluded. And I must say that it is in my genes and in every cell of my body that intense, let's say, fear and distaste for the act of aggression. And the reason, what I want to say is that it is great that we need to broaden our discussion to other security threats, like it was mentioned by Professor Drumbl. But I think that the war of aggression, as it was initially conceived, is the crime that should be dealt separately because of the dramatic moral dimension of it that is lasting for generations for the societies that are affected. And now I know I need to be brief, okay? I want to say, I want to if, as an outsider, okay? This issue of the war of aggression has been sticking with my life. I just wrote a book about it. And what I did, this is a case study of comparing the war of aggression of Nazi Germany and the Soviet Union. One of the shortcomings of our discussion is that at Nuremberg, we couldn't deal with the aggression, the war of aggression by the Soviet Union. It was left aside, and there are tremendous implications for us today because of that conflict of interest of the party who is prosecuting the war of aggression. That's a critical issue that has not been addressed. The other issue I want to say, deterrent. There was a mention of deterrent here. The deterrent, what should be possibly focused on is the propaganda of war and promotion of hatred towards the enemy as a precondition, as a symptom that should be somehow penalized maybe within the national systems. Okay, that's one. I know I'm done. And the last thing is that
Do you have a question for the panelists?
Based on this, the question is, what are the prospects of reforming the United Nations? Because with the 5 votes of the permanent members, this is really a theoretical discussion. And as until we get the United Nations working, this is a dead body of law. Thank you. Sorry.
No fun. To take on that question, but
Well, I mean, there is no true answer to that question. The only thing, from my perspective, I can say is that the reform process is going on. It will take a long time before it's fully achieved. I mean, you have to think that these are states trying to defend their interests and defend also the interests of the organization. It'll never be easy. But it's going to happen. I mean, the prospects to me is that it's going to happen. In what way, to what extent, we don't know.
Professor
Well,
Chavez?
yeah, we're constantly reforming the United Nations. It's not as if it's never been reformed. But you mean removing the monopoly of the 5 permanent members in the Security Council. It's just a euphemism, reform. Yes, of course. But I'm not sure that that's... First of all, I think it's very unlikely to happen, and I'm not sure that it's going to help us very much, because to a certain extent, if we're concerned about world peace, the fact that we created the United Nations and gave the 5 great military powers a kind of a stranglehold on these determinations has, I think, probably contributed to world peace over the last 60 years. And I'm not sure that tampering with it is a good idea. We saw some attempts to tamper with that in 1999, when people started flirting with the idea that maybe we could go outside the United Nations Charter as long as some countries determined there was a humanitarian emergency. And I think people got cold feet about that. A lot of people in the world. I don't know if that was the case here in the United States, but in 2003, when we saw the horror of what happens when you go outside the Security Council. So I'm not convinced that this is the way forward.
We have three quick questions. I think you had one, sir. And then
Yeah, I wanted to ask about one of the contemporary case studies that's in our panel title, which would be the recent war in Georgia. And I was curious to know how the panelists would characterize that. First, I think most generally because it may present a challenge to Mr. Ferencz's optimism about the clarity of the definition. We have, depending on how you count it, anywhere from as many as 3 to as few as 0 aggressors, but we definitely had a war. But more specifically, I wanted to ask about 2 elements that maybe are, and this goes something to Mark's point about broadening the scope of this, that this war suggests may be absent from our definition. And the first, the narrower one, is conflict between a sovereign and the armed forces of another power that are legally or legitimately on its territory. How do we analyze that? And the much broader one, of course, is conflict between a sovereign and an armed group, a rebel group, a civil war combatant, a national liberation movement, all inside the territory. Clearly, one could characterize the conflict between the Sessions and the Georgians that way, and how do we analyze that? So I'd like to have your views on that contemporary case study. Thanks.
Why don't we take some more?
We'll
Let's
take a
some
second
more
one.
questions.
And-
I'm writing it down.
Okay.
I'm slow.
Mr. May.
Okay, so I wanted to ask both Mark and Bill about some things they said about the problems that they saw with prosecuting aggression. So if we think about international crimes as mass crimes, then I'm not sure why things would be different with aggression than in other domains. So, Mark, you've argued, I think, quite successfully and convinced me, in fact, that in the case of genocide, for instance, there are just so many people involved that we can't possibly expect the International Criminal Court or any criminal court to deal with them effectively, that there'll have to be lots of other ways to deal with the other folks who were involved. Various levels of punishment will have to be discussed. I'm not sure why it would be different with aggression. And similarly, Bill, I mean, I guess I agree with you that there's a problem with the proliferation of victim lawyers at the ICC, but I'm not sure, again, why it's going to be that different here. If you think about mass crimes on the model of sort of mass torts, of course we're going to have a proliferation of lawyers. That's just the name of the game whenever you move to the level of mass anything. Why is that especially a problem with aggression that we didn't already have with genocide, which arguably is going to have just as many people?
We'll take one more question, Ben Ferencz, and then we'll get answers. And
Short question to both Mark Drumbl and Bill Schabas. Would you agree that Nuremberg was an important step forward in the development of international criminal law, and that failure to put it in the statute would be a step backward?
Do you want me to?
please.
Let me start in reverse order. Ben, yes, Nuremberg was important. A failure to put it in the statute, I think, would be a tremendous opportunity lost. Limiting the discussion, though, and believing that aggression and the threats that aggression poses to our global community have suddenly been arrested and dealt with and laid to rest simply by codification, I think would be excessively optimistic. So I think an important point for us to underscore is that, in response to, I thought, a very well-made point that arose over here, if aggressive war is the core, it doesn't mean it's the entire fruit of the problem. And I do worry that one of the tendencies of international criminal law or law generally, is to proscribe and stop, and the conversation also doesn't go any further. That's, I think, a danger we need to guard against looking ahead. In response to the question on international crimes as mass crimes and what happens below, the issue here that is disturbing is that if the leadership requirement is absolutely necessary in order for criminal responsibility or liability to attach to an individual with the crime of aggression, then anyone below that level is essentially exonerated from criminal responsibility. And that is not the case with genocide or crimes against humanity. Hence, too high a bar of leadership requirement, in theory, could present difficulties on the national level to go after, hypothetically speaking, a broader array of people if the Rome Statute crime becomes incorporated into municipal law. And I think that thinking about a leadership requirement as having some greater flexibility could obviate that. In fact, there's an interesting article by Kevin John Heller that actually suggests that the ongoing discussions or a retreat, that's the title of his article, or a retreat from Nuremberg, right? I'm not pronouncing on the accuracy of that. I'm just saying that there's a live conversation that we may even be going back in terms of thinking of the policy-making function. So I would say there's a fundamental distinction between genocide, crimes against humanity, on the one hand, as mass crimes, and aggression insofar as how the conversation is going. And I would add, I would really encourage you all to, I mean, I'm sure you've all read them already. Everything is news to me, I guess, but I thought it was amazingly helpful to read the Sakai and Greiser cases, where you really have lower-level individuals who are convicted by two different tribunals of crimes against the peace, and at the end of the day, there is a compelling, expressive, didactic storytelling value to those particular prosecutions, and I don't know if those would be possible anymore today. We're running out of time. I could go on. I'm not.
Final comments, if you'd like. Or...
Ben, Nuremberg, an important step forward, yes, of course. Failure to put aggression in the statute, well, I think that aggression's already in the statute, actually. I mean, it's in Article 5. And I think that it actually can have an impact even in its unfinished form at this point. I thought that when the prosecutor, for example, examined whether or not to proceed with an investigation with respect to allegations of war crimes in Iraq, that he should have taken into account that there was an aggravating factor, that these may have been committed in association with an aggressive war, and that focus was actually mandated by Article 5 of the Rome Statute. But obviously, I'd like to see this process finished and complete itself. I don't know that we'll ever talk about the ICC as being a setback from Nuremberg. Obviously, it's something other than that, but it is discouraging, and it's a political reality that makes it's mainly political realities that make this so difficult. It was one thing for the Allies to meet at the London conference and essentially decide before they even started, the Nazis committed aggression. We're going to make that the theme of the trial. Amongst other things, it simplified things considerably about whether or not they were going to convict them at the end, and I think that may have partially explained their agenda as well. I think they probably were concerned that they weren't sure how to join up the dots in terms of war crimes and crimes against humanity, and so it simplified things to make it aggression. But it's one thing to do that, and another thing altogether to give a prosecutor the authority to proceed on cases of aggression against 107 or 108 states in the world, and that does make it more difficult. Larry's comment about victims, yes, I suppose I was trying to debate another problem altogether, which is the proliferation of victim interests and the complexity of it at the International Criminal Court. But, you know, they can't figure out who are the victims of child soldier recruiting in Congo. Victims of aggression, I just think it's enormous. And Georgia, should I just say, are we talking about the aggression of Georgia against Southern Ossetia, or the... I'm not sure which one we're talking about. So.
But on that topic.
Yes, that's exactly what I'm saying. Is it's very straightforward to conceptualize, Russia as an aggressor. Fits the definition perfectly. But you've got other warlike activities that are very hard. I'm not talking about the facts. I'm not interested in that level. But if you, it seems very difficult to actually conceptualize Georgia as an aggressor if you thought that was sort of a substantive outcome you wanted to reach.
Mm-hmm.
That's a big gap because in fact you do have war and death. And a lot more of it in internal conflicts, so it can be very hard to put into this. I'm not talking about political evaluation, but the conceptualization of it. It seems to be a gap in the definition.
Well, I'm just on the point, though, I do think it's important to underscore at the end of the day that states and their consent to international criminal law is not the only metric that measures the legitimacy of the field. And I do think that probably peoples and populations generally would view a broader array of security threats arising to the level of aggression than states might. And I just think that's an important metric.
Well,
Can I just say something? Not on Georgia, but just two sentences.
two sentences. No.
Yeah. Going back to the definitional task, I think, as I said at the beginning, a lot of good definitions come out of common sense. You don't need to be a legal expert to be able to reach a good definition. In the current process, in the current negotiations, I think that states may wish to take into account that if they don't do a good job in defining aggression, somebody else will. And that will be either the Security Council or the General Assembly or the judges themselves? And the question is, would states, member states, want to be still the masters of the treaty or not?
Thank you very much to the presenters and to all your questions. It was a great panel.
I hate to cut off that dialogue because that was so exciting. We have one more panel before lunch, and it's one of our best panels. So in order so that lunch isn't pushed back so much that you're starving, let's come back in 5 minutes and start the next panel.